Thank you, Can Corla. First of all, I'd like to congratulate my colleague, Joan Collins, for bringing forward this motion, because I think it lays bare the completely unacceptable and totally disgraceful situation whereby redundant workers are being deprived of agreed redundancy payments due mainly to the transfer of company assets. I think the core question that we are asking here today is, how can the law protect employees during the redundancy process and help ensure that limited liability and corporate restructuring are not used to avoid a company's obligation to its employees? Minister, we have sound reasons to believe that the Duffy-Cahill report provides many of the answers to that core question. Existing provisions do not work. We know that. We can see what has happened to the Cleary's workers and now the scandalous situation regarding the Debenhams workers. The Duffy-Cahill report has, as its main objective, an examination into ways in which a similar occurrence can be avoided in the future, and that, of course, refers to what happened to the Cleary's workers. If some or all of those recommendations had been implemented, it's very likely that the Debenhams workers would be paid their rightful entitlements. As Duffy-Cahill says in regard to the Cleary's workers, the transaction that produced this result may have been lawful, but it is difficult to avoid the conclusion that it would be preferable if it were not. And amen to that. Ask any of the exhausted Debenhams workers pounding the streets for over 100 days. Duffy-Cahill looks at the situation where assets are separated from the operation and the operating entity subsequently becomes insolvent and goes into liquidation, and how, in those circumstances, we can ensure the legitimate interests of employees could be more effectively safeguarded. The report is comprehensive, and it doesn't rush headlong into new legislative proposals. For example, it examines whether more effective use could be made of existing employment legislation. It looks at how employees could negotiate better terms and conditions beyond their statutory entitlements, whether employees' entitlements could be ring-fenced in the event of a transfer of an asset, and many other questions. Unfortunately, time doesn't allow me to go through them in detail. But the essential point here is this is a considered, detailed report which puts forward reasonable, credible and workable proposals to help safeguard redundant workers' entitlements. I know that you, as Minister, and your government do not want to see Debenhams workers left without their rightful entitlements. But expressing regret and sympathy is fine as far as it goes, but it is utterly useless. It's basically redundant for the redundant workers because it doesn't solve their problem, and it won't solve similar problems in the future. So I think, Minister, everybody, no matter which side of the House you're on, recognises that we need to amend our legislation, and if nothing else, this report provides a sound basis for doing that. Now, I was particularly interested to look at some of the legislation that we now have in place and its inadequacies to protect workers who are made redundant and companies transfer their assets. Now, much of this legislation is derived from EU directives. And while there are some protections in place, and I would instance the fact that over 1,500 redundant workers in Waterford Crystal were able to use EU legislation to vindicate their rights and entitlements, where the ECJ ruled in their favour and against this state in the case of underfunding of a company pension scheme. All I will say is it is never easy to take on the power, the might and the resources of the state, but these workers did, and they established those rights not just for themselves but for all Irish workers subsequently, and congratulations to them. But nonetheless, the forensic examination by Duffy Cahill of existing provisions in Irish law that derive from EU legislation shows that these provisions, as we already know, are inadequate to protect redundant workers in the situation of transfer of assets. We also know from the fact that certain European countries, for example Germany and Austria, have unilaterally established levy funds on private sector employers for this very purpose, because EU legislation does not provide the required protections. Of course, one of the main reasons for this is the existence of a strong tradition of collective bargaining in these countries, something that's missing in Ireland. But taking a closer look at some of the relevant legislation, the Protection of Employees Act provides for consultation of workers. However, Minister, it's telling that a successful case was taken against Ireland to comply with the requirements of the underlying directive, the Collective Redundancies Directive. And we had to comprehensively rewrite our legislation after we lost the case, because we had legislation that allowed employers to allow somebody else to control the operation and to basically hide behind the situation where they would say, we didn't know what was going on. But the ECJ insisted we change our legislation. I mean, when I think that that get-out clause was there in Irish law for employers, it's just incredible, and perhaps indicates something far deeper about how we sometimes transpose EU legislation. And while I don't have time today to deal with that issue, it's certainly one of several examples that I know of where EU legislation was not transposed into Irish law with a view to protecting the individual, the ordinary person, the worker, but rather sought to insulate the state in some cases and corporate interests in other cases from adhering to the requirements of specific EU legislation. I was also most interested in the directive on the protection of employees in the transfer of undertakings, that particular directive. But unfortunately, neither the directive itself nor our legislation provides any realistic mechanisms for protecting workers where, in cases that the essential assets of the business, as opposed to the business itself, are transferred. So the conclusion is that none of our employment law, as it currently stands, could be safely relied upon to provide redress in the current situation. I think another area worth looking at is the Companies Act. And there are some possibilities here where any transfer of assets was conducted with the intention of perpetrating a fraud, for example, to deliberately deprive redundant workers of their rights. If you could prove this in a court of law, then you could have redress. However, tellingly, Duffy Cahill states that in regard to any court application, the likely complexity and the costs it would entail would make it an unattractive prospect for creditors with limited resources. And surely that describes the Debenhams workers, creditors with very limited resources. So, in simple language, Minister, no worker, no trade union could attempt to use the provision in the Companies Act because they simply couldn't afford it. So finally, can I say that current legislation needs to be amended to provide protections to redundant workers in the case of transfer of assets. And Duffy Cahill lists 6 different proposals to deal with this. My colleague, Joan Collins, has gone through these proposals in detail, which, taken as a collective, could help to provide the missing safety net for workers who find themselves in the position that the Debenhams workers now find themselves in. I honestly believe these proposals are credible. I think they're well researched, and I think they have a sound legal basis. And I'm asking you and your government to give them the serious consideration that these proposals deserve.